So what happened at the court today is that whilst everybody was ready for the pre-trial, which is the pre-trial being the two parties to determine the issues at stake, Mr. Tsikata came up with an application that had to be discussed. And the application is entitled Interrogatories. And so we will start with the meaning of interrogatory. So we went over to Black's Law Dictionary. Before we start, though, let's just look at this. So this is the election petition of 2020 and 2021. It's John Mahama, who is the petitioner. The first respondent, about whom there was a lot said today in court, is the Electoral Commission. And the second respondent, Nana Danko Akufo-Addo, whose lawyers, Tony Akuto-Ampao and others, also had the go at court today. So now, what is interrogatory? So what Mr. Tsikata filed today is interrogatories. What is it? We have to understand it. So we went all the way to the Black's Law Dictionary, which is the authoritative book as a legal dictionary to explain legal terminology. So interrogatories is a written question or set of questions submitted to an opposing party in a lawsuit as part of a discovery. Interrogatory is as part of a discovery. So we decided to find out what is discovery, because quite clearly discovery had also been used within a legal context. So we went over here. What is discovery? The act of process of finding or learning something new that was not previously known. That's what discovery is. Discovery is a practice in the law where lawyers go and file an application for discovery. And interrogatories, which Mr. Tsikata filed this morning, is as part of discovery. Okay. Discovery is also compulsory disclosure at a party's request of information that relates to the litigation. That's very interesting. Now, that's the other meaning of discovery. Compulsory disclosure at a party's request of information that relates to the litigation. Now, you come back down here and you'll find this. The primary discovery devices are interrogatories, which is what Mr. Tsikata filed this morning, depositions, requests for admissions, and requests for production. Although discovery typically comes from parties, courts also allow limited discovery from non-parties. So you understand it now. Discoveries will usually come from parties, but as the law says, courts also allow discoveries from non-parties. Okay, let's move on. Okay, so discovery is also about facts or documents that are to be disclosed. So what Mr. Tsikata filed this morning, filing the interrogatories, he is looking for facts and documents that he wanted the Electoral Commission to disclose. Now, this evening, we're going to take you through, this is the last definition of discovery, the pre-trial phase of a lawsuit during which depositions, interrogatories, and other forms of discovery are conducted. So that's from the Black's Law Dictionary. You see it here. The pre-trial phase of a lawsuit during which depositions, interrogatories, and other forms of discovery are conducted. Okay. So we will now take you into the details of what Mr. Tsikata filed. Now, at each stage, there are 12 of them. We'll run through them very quickly. At each stage, we will tell you what the MPP said, what was the MPP and the Electoral Commission's response, and then eventually we'll play to you the ruling of the court. And keep in mind that at the beginning of this process, we looked at all the judges, and we told you about the judges, and we told you that the president of the court, His Lordship Justice Eni Yeboah, the president of the court and the learned Chief Justice, has, in his practice, demonstrated fidelity to procedure. We told you that. He demonstrated fidelity to procedure. This afternoon, it came out in his ruling for the court. So Mr. Tsikata starts and says, on behalf of the above-named petitioner for the examination of the above-named first respondent, pursuant to the orders of the Honorable Court, blah, blah, blah. Okay, so this is not important. Let's start. Number one. This is the first question Mr. Tsikata is asking in the interrogatories. Number one. Was there a practice in previous presidential elections in the Fourth Republic of collated figures from constituencies being received in the strong room at the headquarters of the first respondent in the presence of agents of the candidate? This is the first question that Mr. Tsikata put to the Electoral Commission. So the interrogatory set of questions, the Electoral Commission should answer. He filed it this morning, and when you file it, the Electoral Commission must answer in written response. There's precedent to that, by the way. In 2013, the petitioners also filed interrogatories. That was granted, and the questions were answered by the Electoral Commission. Now, let's look in detail at one by one of the questions up until the 12th question. So this is the first question. Mr. Tsikata is asking whether there was a practice in previous presidential elections where constituencies received the results in a strong room before party agents. The response to this from the Electoral Commission and the MPP was that this is an irrelevant question. That's what they said. They said this is an irrelevant question because every election is guided by the law, a constitutional instrument. This 2020 election was guided by CI 127, and CI 127 set out the rules for the election. So whatever happened before, whatever would happen tomorrow is totally irrelevant to election 2020 because the rules were set out, publicly known, precisely set out through Parliament in a constitutional instrument entitled CI 127. So the MPP lawyers and the Electoral Commission lawyers were arguing that point 1 was irrelevant. Okay, let's go to point 2. What the judges said, we will tell you. We'll show you the video so you can see it. But we're just telling you what Mr. Tsikata said, what the other guy said. So, number 2. Mr. Tsikata asked the question for John Mahama. Was that practice described in paragraph 1 herein, followed in respect of the 7th December? Okay. So, the respondents argue that this is also irrelevant because it follows from 1. Number 1, Mr. Tsikata is asking, was there something else happening in the past that didn't happen this time? They said it's irrelevant because every election has a law. CI 127 was clear. It was published long before the election. Everyone knew how this election was going to go long before it occurred. So number 2, they said it's irrelevant as well. Number 3 is the 7th December presidential election. The first time regional coalition centers have been interposed between constituency coalition centers and the headquarters of the first respondents. You remember that ahead of the election, the CI 127 again said in this election there will be regional coalition centers. Greater Accra region will have a coalition center for the presidential election. Ashanti region will have theirs. All of that was decided in CI 127. So CI 127 was clear. That's what the law said. The Tsikata is asking that, is it the first time it happened? And then the respondents say, again, it's an irrelevant question because it is in the law. You saw the meaning of discovery, something that's unknown. They said this is very, very well known. It's in the law. It was not necessary as far as they are concerned. Number 4, how were results transmitted from the constituency coalition centers to the regional coalition center? Again, Mr. Tsikata wants to ask this question of the Electoral Commission, and he was told by the respondents before the court ruled. The respondents are the Akufo-Addo lawyer and the Electoral Commission lawyer. The Electoral Commission is the first respondent, and President Akufo-Addo is the second respondent. So when we say the respondents, we mean them. The respondent said here that this was also irrelevant, that of what basis was it of how results were transmitted, and how results were transmitted would be contained also in the CI 127. Okay. Number 5, he said, how were results transmitted from the regional coalition center to the headquarters of the respondents? Following from point number 4 again, they argued that this also is not a relevant question. It's not germane to the petition. So this question, in terms of the interrogatories, should also be denied. Number 6, Mr. Tsikata was asking for John Dramani Mahama. Did the National Communication Authority facilitate in any way the transmission of the results to the headquarters of the first respondent? Now, this became a big argument in courts this morning when Mr. Tsikata asked about the National Communication Authority. The respondents wondered what Mr. Tsikata wanted that kind of information for in terms of how results were transmitted, because, again, the law, the regulation, CI 127 regulation said the results will be transmitted by a fax machine. That's what Justin Amenuvo told the court. In his response, Justin Amenuvo is a lawyer for the Electoral Commission. In his response, he said this is very obvious. It is in the law that fax machines will transmit the results. Okay, so they said this also was irrelevant. Number 7, when did Jean Adokwe Mensah, the chairperson of the first respondent and the returning officer for the presidential election, first realize there was errors in the figures that she had announced in her declaration of 9th December 2020? This was a tough contention among parties because, as you know, the lawyers for John Dramani Mahama, led by Mr. Tsikata, have been compelled to file a special motion to amend the original documents that they sent to the court. So as part of the court's records, there's record now that President John Dramani Mahama filed a motion to make changes in the errors that he first presented to the court. So this question of errors and errors is all over the place. So Mr. Tsikata comes up with question 7 and says that when did the Electoral Commission recognize and realize that they had made errors and that they wanted to change? People, the respondents were asking him that what's the meaning of this? Because as far as the respondents are concerned, the Electoral Commission made mistakes, they admitted the mistakes in a press release, and most importantly, they have gazetted the original and final results of the presidential election in a gazette instrument. That's a law. And that is what is required by them of Article 63(9) of the 1992 Constitution. Article 63(9) requires the Electoral Commissioner to gazette the results of the presidential election. The respondents were telling Mr. Tsikata that given all the facts and given all the circumstances, this question is totally irrelevant. To tell us, for Jean Mensah to tell us when she found out that she had made errors. So she made the broadcast sometime at 4 o'clock. The question requires her to say that 2 hours after the broadcast, I've realized I've made mistakes. 3 hours after the broadcast, immediately I finished. In the middle of the broadcast, I made mistakes. That's what this question is asking Jean Mensah to do. So, well, the respondent said that it's a totally irrelevant question. Question number 8. How did Jean Adokwe Mensah, the chairperson of the first respondent and the returning officer for the presidential election, get to realize there were errors in figures she had announced in her declaration of the 9th of December? Again, this was also directly linked to the same matter. Jean Adokwe Mensah makes a declaration. She finds that mistakes. The next day, she publishes a press release. Mr. Tsikata is asking that, how did she find out? So this question is asking Jean Adokwe Mensah to say, for instance, that I was told by Mr. Bossman, who is my deputy. I was told by my accountant. I was called by somebody who had done the calculation. A family member called me and said you had made a mistake, or some other person called me from the Electoral Commission, or somebody abroad, or a foreign journalist, or a local journalist called me and said you had made mistakes. That is the request of this question. And the respondent respectfully told Mr. Tsikata, again, relating to question number 7, that is an irrelevant question. Okay, number 9. It said, in respect of the purported corrections made to the figures in the declaration by the first respondent, was there any prior process of conferring with the agents of the presidential candidate? Mr. Tsikata says, in respect of the purported corrections made in the figures, was there any process of conferring with the agents of the presidential candidate? Again, the respondent said this was irrelevant. So what this question is asking, is inviting Jean Mensah to say, is to say that yes, when I was about to do the corrections, I told the agents of the presidential candidate, or no, I didn't tell the agents of the presidential candidate. That's all what this question is demanding. The respondent said that it was, again, an irrelevant question. Number 10. Did Jean Adokwe Mensah, the chairperson of the first respondent, present Form 13 or 1.3, the declaration form, the presidential results form, to all the agents of the presidential candidates to sign? And if so, did all the agents sign? Now, Justin Amenuvo was quite furious about this question because as far as he's concerned, this question is answered in their affidavit. In their affidavits, they indicate that results were transmitted from the polling station, and the rules were that whether it is completely signed by all candidates or some didn't sign, it will move to the Constituency Coalition Center. From the Constituency Coalition Center, if it is signed or not signed, it will move to the Regional Coalition Center. From the Regional Coalition Center, it will move to the National Coalition Center. MPP didn't sign some, and NDC didn't sign some. CPP didn't sign some of it. All of that, the Electoral Commission lawyer, the lawyer for the first respondent, indicates that everything is documented in the affidavit, of which Mr. Tsikata has a copy. Again, they told him this question is also irrelevant. Question number 11. On which date did Jean Adokwe Mensah, the chairperson of the first respondent, post a copy of the Form 1.3 at the head office of the first respondent? This one also, Justin Amenuvo came in strongly and said that no, the document was posted there. The date on which the document was posted, it's on the document. It's affixed, as the lawyers say, affixed on the document that is posted at the Electoral Commission. And therefore, with the greatest of respect, this question, again, was said to be irrelevant by the respondent. Now, it says, question number 12. Did the first respondent record any discrepancies which were occasioned by computational and mathematical errors in the course of the collation of the results? Once again, Mr. Tsikata was said this question is also irrelevant. The most important thing is that the results of the presidential election 2020, pursuant to Article 63(9) of the 1992 Constitution, has been gazetted in a gazette instrument that can be found at Assembly Press. That gazette instrument is the basis on which the swearing-in has occurred on 7th of January 2021 at the State House, the Parliament House, which was chaired by the Speaker of Parliament, so duly elected, and it was there were representatives from all over the Africa and some parts of the world, diplomatic community and all of that. All of those people gathered at the State House, Parliament House, at the forecourt of Parliament to witness the swearing-in of the president based on the gazette instrument that was signed by Jean Adukwe Mensah as being the final and confirmed results of the presidential election 2020. And in doing so, the law in Article 63(9) imposed that on her. So they argued that all the 12 questions of Mr. Tsikata's interrogatories were all irrelevant. They urged that upon the court. And what did the court say? How did the court rule? We know that the court dismissed this. But what did they say before they dismissed this? Let's go and look at that. Let's have a look at that.
Interrogatories under common law is discretionary. It should be granted or refused when all the circumstances are taken into consideration. It should be noted that the questions seek to elicit should relate to the issues raised and the relief sought in the petition. Interrogatories must be relevant to the issues and relate to the matters in controversy between the parties. In this petition, the petitioner and the first respondent. The court is of the opinion that the crucial issue of relevancy has not been established in this application. Reference was made to the 2013 election petition titled Danado Dankwa Akufo-Addo and two others versus John Mahama and two others, 2013 Supreme Court Organo Law Report, Special Edition, page 50, in which an application to serve interrogatories was granted by this court. However, subsequent to 2013, several statutory amendments have been made by CR 99 of 2016, which has restricted the practice and procedure of this court as regards election petition. Indeed, Rule 69C4 of the Supreme Court Amendment Rule CR 99 directs the expeditious disposal of the petition and sets timelines for this court to dispose of the petition. It implies that even amendments ought not to be granted then, as well as joinder of parties. Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR 90 and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application and same is accordingly dismissed. We are grateful to the court. I am most grateful.
Okay, so you saw that. That was Eniebua speaking. Now, at the close of day today, Mr. Tsikata filed something else. And he's filed with Tony Lither's signature that the Electoral Commission, and that will be dealt with tomorrow, the Electoral Commission, that's the first respondent, must deliver all the documents for the election, the results, the coalition sheets, and all of that. You remember that in preparing our viewers for this election petition, we cited this quotation from Adom-Otchere, Sophia Adom-Otchere, from the election petition 2013, and it's as follows. Let's have a look. She said, "It is our thinking that where a party is already in possession of a copy of documents mentioned in another party's pleadings, it is unnecessary to apply or for the courts to make an order for inspection and making copies of the documents in question. By virtue of the Evidence Act 1975 NRCD 323, Section 166, the duplicate copies of these documents are admissible to the same extent that the originals in the custody of the second respondent." That's the Electoral Commission. What Sophia Adom-Otchere was saying to the court at that time was that the MPP were asking for original documents from the Electoral Commission, and she said, no, you already have it, so you should bring it. I'm guessing that the MPP lawyers, the first respondent and second respondent, in reaction to Mr. Tsikata's application, are going to rely on this. We do not know what the court will do and how they rule, because the Supreme Court has excessive powers. They can depart from their own ruling. They can do anything they want. They can decide on how they rule based on the law. But we are just bringing this to your attention so that tomorrow when it comes up, you already know it and it can form part of your thinking. So that is our report from courts today. Now, as we said, we are designing a new studio every Thursday for the next 4 Thursdays. We'll be focusing on election petition with some of the lawyers in the studio. Thank you very much. We'll be right back.